Today we're privileged to speak with Don Hammond, a Los Angeles County attorney who we met several years ago through our affiliated instructor, Edmund Tan. About a month ago, Don mentioned a problem he had solved for a client who had applied for a concealed carry license. It was interesting, and it mirrored a Supreme Court case that was in the news at the time. He has agreed to tell us about the Los Angeles County case and the bigger picture that it echoes. Thank you for meeting with us, Don. Can you give us a little introduction to yourself and your bio, if you will?
Sure. Well, thank you very much. I didn't prepare a bio for this, but yes, I am Don Hammond, of course. I'm a criminal defense attorney. I'm the founder of a law firm called Criminal Defense Heroes, based in Torrance, California, which is in Los Angeles County. I have a pretty varied practice, both geographically as well as criminal defense focused and firearms based as well. I have cases open right now from San Diego to San Luis Obispo and out east to Indio. So I travel a lot. I'm on the road a lot. It also helps that I happen to be a pilot and a flight instructor. So if necessary, for example, on Monday I flew to court in Santa Barbara. But I do a lot of gun stuff as well. And my current, I've been shooting since I was probably 8 years old. First time a shotgun knocked me on my butt. And I have now become a certified shooting instructor. I regularly teach classes with Edmund Tan out of Shoot Safe Learning in Lomita. In fact, just this past Sunday, I was out at the range with him teaching a concealed carry class. California now requires a 16-hour class, so we do 1 day in the classroom, 1 day out at the range. And sometimes I'll come into the classroom to talk about California's gun laws, particularly as they apply to pistols and people who are getting concealed carry licenses and what that looks like, the kinds of, carrying, transporting, using, all this, borrowing, loaning, all the California legal stuff that goes along with owning and having firearms, because California, of course, hates those of us who have firearms. And then the second day out at the range, I help teach all the tactical stuff and all the, do the qualifications and all the things people need to know so that we can do it safely and legally and hopefully stay out of trouble. I always say I'd rather talk to people in advance and let them know how to do it right so they can stay out of trouble rather than have them in my office 3 or 4 months later because they did something they shouldn't have.
Well, that's awesome. And I'm wondering about your caseload. Is most of it regulatory gun law? How often do you get a genuine self-defense use of force case?
Practice is pretty broadly criminal defense. So I do a lot of gun cases. 2 out of the 3 cases I was in court on this morning have to do with what California calls assault weapons that are not supposed to exist in California. And 2 of my clients from this morning are accused of having those guns in California that they're not supposed to have at all. So, fairly frequently I'm defending those kinds of gun cases. A lot of it is possession. I'd say 2 or 3, maybe 4 or 5 times a year I have a genuine self-defense type of case. Where somebody used some level of force. The most recent one I'm thinking about, somebody actually used pepper spray. They have a CCW license and they were carrying their gun, but they, for this situation, they didn't go straight to the lethal option. They used pepper spray, and I was able to talk to the police about it and get them to not even file the case because I persuaded them that he's a responsible citizen who has a permit that he didn't use, and he chose to de-escalate the situation in another way, and that there was self-defense, and I persuaded LAPD to let that one go and not even file the case.
Bravo.
Right? So yeah, those things happen pretty frequently. And then self-defense comes up where, sometimes it's imperfect self-defense, sometimes it's not real clear, and we have to make the argument, right? I mean, I wish it was always black and white as to whether this was a clear self-defense or what's going on. But it comes up all the time, in bar fight cases, right? Who threw the first punch? Was it self-defense? Who was actually at fault? So self-defense cases come up pretty regularly. Very familiar and have litigated cases regarding, California's castle doctrine, duties to retreat, and those kinds of things. I was recently defending a guy who's actually he's a Navy DOJ police officer in Florida who was out here in California on a medical issue, getting treatment, and he was out and about in one of our beach cities here in Southern California in LA County, and got into a road rage incident where the other guy actually got out of his car and was coming toward my guy, and he pulls his off, well, allegedly, my guy pulls his off-duty weapon and points it at the guy, which has a tendency to defuse the situation rather quickly. But then, of course, the other guy called the cops and said, hey, this guy just pointed a gun at me. My guy gets charged with assault with a firearm. And we actually have that case on track for dismissal right now through actually a mental health diversion where we have it. He's getting some treatment, and the case will ultimately be dismissed. So, sometimes, getting the sure dismissal is better than picking 12 and trying to fight it head on. But, case dismissed is case dismissed.
Well, I would consider that a win. And going back to the regulatory side of things, about a month or so back, in fact, maybe it's been 2 or 3 months now, you had success appealing a denial of a concealed carry license in Los Angeles, but without violating the guy's privacy. How did the denial come about, and what did you do that solved the problem? And for members from other states, why was overturning that denial so very unusual?
Sure. So a little bit of background on that. Senate Bill 2 was a major change in the law in California. It changed a lot of different aspects of California firearms laws, including some of it is on hold because Senate Bill 2 is the California legislature's response to Bruin primarily. So historically, it was nearly impossible to get a concealed carry license in California's more populated counties, like LA County. They just weren't issuing them. They had the good cause standard. Bruin, of course, shot that down, and so they had to start issuing some. Over the last 2 years or so, then, the most common reason for denial was a moral character denial. Very broad, very subjective. The chief of police or the sheriff in the county says, we think you've got bad moral character, so we're not going to give you a license. And of course, they could apply that to almost anybody. So the new law under Senate Bill 2 that took effect January 1st of this year eliminated the moral character requirement. It overhauled the entire system, and it put out some pretty specific reasons for denying a license. The most general reason now for denying a concealed carry license is what they call reasonably likely to be a danger to self, others, or the community at large. Right? Whatever that means, right?
Reasonably likely.
Right. It sounds like a some evidence standard, right? It's pretty broad. So, and then there's a list of reasons for presumptive denial, like certain convictions within the last 5 years, certain convictions within the last 10 years, having a restraining order within the last 5 years, being irresponsible with firearms and getting them stolen, bunch of things. There's a whole laundry list of things in Penal Code Section 26202 that says presumptively you can deny a permit if somebody has any of these things in their past. The first part of that, though, says unless a court makes a contrary determination pursuant to 26206, this list of things are reasons to deny somebody. So then, of course, you look at 26206, which created an appeals process. So if somebody is denied a license by either a local police chief or a sheriff, we have the right to appeal it into a court and to get a ruling from a superior court judge. And so that's what we did for this guy. A local police chief had denied him his license, and I'll get into the reasons in a minute. But then within 30 days, we have to file a request for hearing. This was the first one in LA County. So I went around to a bunch of different clerks' offices and was like, where do I file this thing? How do I file it? Who wants it? And finally got to the right place and got it set. And now I know that this same judge in downtown LA is going to hear all of these, and it should be the same DA on the other side of them. So we'll develop some sort of institutional knowledge of each other and how these. This particular guy had a domestic violence arrest about 10 years ago in 2014. It was just an arrest. It was a DA reject. No case was ever filed, so obviously he wasn't convicted. The arrest record has not since then been sealed. But as a part of that arrest, the police got a judge to issue what we call an emergency protective order. That's a 7-day restraining order that happens very commonly as a part of a domestic violence arrest. And it basically says, no contact for 7 days. It's designed to allow the complaining witness or the victim to go to court and seek a domestic violence restraining order or some other kind of protection. It just gives them that sort of safe harbor time period to go do that if they want to. In this case, this guy's wife never did that. The issue was just gone, right? This restraining order dissolved on its own after 7 days. He had no reason to even think about it for the last 10 years. So on his CCW application, he says, yep, I was arrested 10 years ago by the same agency that I'm applying with. I'm not hiding anything here. But he completely forgets, because there's another question on the application that says, have you ever been the subject of any kind of a restraining order? You know, he received this piece of paper 10 years ago in a pile of paperwork that he got as he's leaving the jail. He's had no reason to think about it since then. So he says, no, I haven't been subject to any restraining order. What are you talking about? So they get through the process, and the licensing agency, the police department, initially says, well, we're denying you because you are subject to a restraining order. And he says, well, what are you talking about? I've never been subject to any restraining order. So we have a little bit of a back and forth by email, and they say, oh, it looks like you're right. Well, we're going to deny you because you failed to disclose this protective order on your application, though. Basically grasping at, like, well, what else can we use? By the way, there's nothing in the law, as currently framed, that says that failure to disclose is a reason for denial.
Oh my goodness.
But we're seeing this all the time now. We're seeing it very frequently that somebody forgets about something from a long time ago, or they misunderstand the question, or for whatever reason they're not disclosing it, and these agencies are issuing denials for failure to disclose, which is not correct. Now, and the judge brought this up at the hearing, there is a criminal statute for knowingly failing to disclose something on an application. They could prosecute you if they can show that you knowingly failed to disclose something. But they can't prove that he knowingly did that. He had no reason to think about this thing. They could also revoke a permit. There is grounds in the statute for revoking a permit if they discover something later that they didn't know when they granted the permit. But that's not the denial of the application in the first place. So, maybe we're splitting hairs here, but it is, there's nothing in the law that allows them to deny a CCW license because of a failure to disclose. So I, drafted a brief, explained this. So this was the first one a judge had even heard in LA County. We actually ended up continuing the hearing once because some of the paperwork wasn't in order from the other side. And I showed up and we talked about it, and I convinced the judge that they should. So in this hearing, the prosecution, it's actually set up where a district attorney, a prosecutor, has the burden of proof by a preponderance of the evidence. So 50% plus a feather is the way I think of that. The prosecutor has the burden of proving by preponderance of the evidence that the person should be denied a permit, that they are a prohibited person under 26202. And so the judge found that the prosecutor failed to meet the burden of proof and ordered the local police department to please issue a license to my client. So that was the big win there.
Happy client.
Yeah, very happy client. I was actually just following up with him, and this was about a month and a half ago, and it looks like they are not responding to him now. They said, hey, it should be available in a couple of days. That was back on July 2nd. And he's followed up a couple of times, and now we get to figure out what our next step is because they still have not actually given it to him despite the court's order.
Right, so they're going to slow walk it and involve you some more because they figure at some point the citizen may give up.
I guess so. I mean, next I'm going to write a very kind demand letter to the city attorney and say, hey, tell your chief to get his act together. And then we'll have to consider, what the next step would be in terms of a petition for writ of mandate or something to get the court to enforce. Well, and if I win that, I expect attorney's fees from the department. So
why was it unusual because SB2 was fairly new? Have there been a raft of these kinds of denials since then? Is this the only one on record? What's our frequency here? What are you going to become the expert on this that everybody goes to in California?
I hope so. I plan to be that expert because I honestly don't know any other attorneys who were actually doing these hearings. Whereas, I mean, that was the first one a judge even decided in LA County, and I did it and won it. So, nobody else has that experience, I can promise you. I did have one the following week that I lost, in all fairness. In that case, the guy had 2 separate domestic violence arrests in his past, no convictions. but that police agency did a psych report as a part of their evaluation, and the psych said, there's stuff in this guy's background that could be a problem, could indicate dangerousness if you issue him a license. And the judge was not willing to go against the psych to overturn that one. So I encouraged my guy to appeal it higher up to the 2nd District, and he didn't want to. So, it's just going to die. He can reapply in 2 years. I have another guy who I had spoken with 3 or 4 times prior to his hearing on the same issue, and I had laid out some arguments for him. He decided not to hire me to help him with the hearing, and he went and messed it up and lost the hearing. And now he's hired me to file an appeal to the 2nd District appeal of the hearing that he went and lost. And I'm like, well, I'm not sure I predict a great chance of success here because I don't know what you said at that hearing. I'm working on getting the record and doing all that so that we can do the appeal. So that is happening. And then a few weeks ago, I happened to be in court down in Orange County on another firearms issue related to a restoration of rights after what we call a 5150 hold, which is a mental health hold the police can put somebody on. It triggers a 5-year denial of firearms rights. But there's a hearing process very similar to go restore rights. This guy's a very accomplished security guard. He makes a living with his gun. It was a pretty bogus 5150 hold, and so we're working on getting him his firearms rights back. But while I was there, I saw a pro per guy get up, and it was the very first one an Orange County judge was going to decide under 26206 for a CCW license appeal. And nobody knew what was going on. The judge said, "What is this? I'm going to have to read this statute and figure this out." The prosecutor is standing there bumbling, saying, "Well, it looks like I have the burden of proof here. I don't know what we're supposed to do." And of course, the poor appellant there trying to get his CCW license is like, "Well, I don't know how to do this either." And so as he was leaving the courtroom, I slipped him a card, and he's now a client. And so I will be the attorney representing him on the very first one of these that will be decided in Orange County. So yeah, the short answer is yes, I think I'm going to be the guy because I know that nobody else has done it in LA County, and I'm about to be the first one to do it in Orange County to even hear one of them, let alone win one.
So the timing on this, is this all happening because, well, presumably Bruin triggered SB2? Is there a sequence of events, and how much did you make use of Bruin principles in getting that application accepted? Do you see Bruin as making a big difference when you're arguing these?
I think that it does. It's sort of background, right? Because we're within a statutory framework, and the judge at this point feels that they're confined to the statute in terms of what is admissible in these hearings and those kinds of things. But when I file a brief on one of these, I start with Bruin and Heller that, hey, this is a fundamental right that we're talking about here, and lay out a little bit of the history of how we got to where we are. And this is the legislature's response, some of which is on hold already with injunctions from the courts. So take this all with a grain of salt, Judge. But the Supreme Court has said that we have an individual right to carry firearms for personal protection, and we don't have to justify it individually or any of that. To me, this whole permitting process is suspect. But we're going to work within it while it exists until we have solid grounds to challenge the whole process, maybe. So yeah, that's the background of it, and I think a lot of the judges don't follow this stuff. They're not gun people. So I think pointing that out, that the Supreme Court has reinforced this, and now even Rahimi, even though they said that guy can't have guns, there's a lot of language in there that, yeah, this is an individual right, and any restriction on it, like in Rahimi's case, is going to be, after specific findings. It's going to be a temporary, limited restriction, and denying somebody who has a clean history a permit because they didn't reveal something, or because you feel like it, because you think everybody's reasonably likely to be dangerous if you let them carry a gun. That doesn't fly. We're talking about fundamental rights here, constitutional rights.
Well, and I've got a lot of questions about Rahimi. Can I take you back to Bruin? Just one last thing about Bruin is how much has it actually in a restrictive state like California opened up carrying a gun legally for self-defense, and how much of that was countermanded by the quick imposition of new restrictions like so-called sensitive places and other novel restrictions? Has it done that much good for us?
I think it has done a lot of good. And I think that that's why our sensitive places restrictions in SB2 is on hold right now. It's because of Bruin. Chuck Michel and his crew with the California Rifle and Pistol Association and his law firm is pulling the laboring oar on all of these lawsuits that are getting us these injunctions. And they're doing a fantastic job at using Bruin to squash some of the more egregious parts of the new laws. Like I said, Senate Bill 2 was passed as California legislature's response to Bruin. And so they basically said the entire state is a sensitive place. So even if you get a license that won't do you any good, you can't carry anywhere, is basically what it said. They flipped the current thing with most private businesses, like, walking into a grocery store, is you can, if you have a license, you can carry there unless there's a sign that says you can't. And I always say, well, you're allowed to not see the sign also, right? I don't have to walk around all the time looking for signs everywhere. So Senate Bill 2 tried to flip that on its head and say, you can only carry where there's a sign that says you can, right? Otherwise, it's a sensitive place, right? And so that's all on hold. So right now, we're status quo in terms of where people can carry with a valid license. And that's all Bruin-based right there, for sure. As far as these kinds of hearings, they've had to loosen up the standards for giving out licenses. And I think that it's a huge step in the right direction that they've created this process for essentially an expedited writ of mandate, where a local agency denies somebody a carry license. We have 30 days to file the request for hearing. They have to give us a hearing within 60 days. But it shows that they're taking this seriously in some respects, that we actually get the hearing at all. And then we get to go convince the judge to go ahead and overturn the agency and say, no, this isn't good enough. Give them a license. And I think judges in many ways are more apt to respect the law than cops are.
When I read about your carry license case and the long past restraining order of brief duration, no less, echoed in the Supreme Court's ruling in Rahimi, which, if I understood it, raised questions about denying gun rights to people who are or have been under domestic violence restraining orders. How much did Rahimi water down the Bruin decision's instructions on how to analyze and apply the Second Amendment? I mean, Justice Thomas wrote that it defeats the purpose of historical inquiry altogether. What's your take on that? Did it?
I think Rahimi... I actually wrote an article for the Daily Journal on this, which is California's local newspaper. And my title was Bad Facts Make Bad Law. And this is a terrible set of facts to take up to the Supreme Court. And I don't really begrudge them bending over backwards to find a way to keep guns out of this guy's hands. I think everybody, I think I said in the article, everybody in the world except Justice Thomas agrees that Mr. Rahimi should not have guns, right? Like, I have no problem with that. I think that there is confusion in the way the Supreme Court got there, in that it gives very poor guidance to lower courts, right? Since Bruin, all of the circuit courts and the district courts are struggling with, okay, how do we apply this standard? Well, for example, in Bruin itself, they said, usury laws aren't going to be good enough as a historical precedent. But then in Rahimi, they said, surety laws, not usury. They said, surety laws aren't going to be close enough historical analogs to deny gun rights. But then in Rahimi, they turn around and say, surety laws existed, and those are close enough, and so we're going to use that as our historical analog. What's a lower court
What
to
was
do?
a surety law?
A surety law is basically post a bond, right? If we think that you might have some tendency toward violence, we're going to ask you to post a bond so that if you hurt somebody with your gun, then we have this bond that we can go against and get them money. It's all about money. But it was a way of disarming people. If they didn't want to post the bond or whatever, then they weren't allowed to carry a gun. So Supreme Court in Rahimi says, that's a close enough historical analog that if we think somebody has something in their past and we would have them post a bond, Now we'll just say, well, if they have this in their past and the court makes a finding that they're dangerous, then we'll just take their guns away for the duration of their restraining order. It's key in Rahimi, though, that they sided with that perspective because it's a limited deprivation of rights, right? It's for a limited duration. It's not a permanent thing. And one of my questions when I'm looking at these cases in California related to these concealed carry denials is what stops this from being a permanent deprivation, right? If we lose the 26206 hearing in court, that triggers a 2-year waiting period before they can apply again. But doesn't that mean especially if it's just a very general denial based on, reasonably likely to be a danger, how long is that good, right? Say something happened 15 years ago and they say, okay, you're reasonably likely to be a danger because of that, and a judge upholds that. Well, applying again in 2 years, I can't change that fact.
Yeah.
Right?
Yeah, does it just recycle?
Right. So at what point is it aged out, right? At what point is it, well, that's not usable anymore? And actually, I'm gearing up to brief one where I'm going to cite to a case that I know about from the parole context. I've done some lifer parole hearings to bring people home who have been in for 20, 30, 40 years. And there's a case from back, actually 2008, I think it was. Some of my law school colleagues worked on it, called In re Lawrence, that says the immutable factors of the commitment offense are no longer probative of present danger to society after a number of years and rehabilitative steps. And I think that we're looking at the exact same thing in this context, right? After some number of years and other things a person has done in their life, you don't get to keep using something against them that happened a long time ago. So I'm actually about to brief that argument in one of my cases and cite to Lawrence, which it's a case that I just happen to have. You never know where things are going to be useful, right? I happen to know this thing from a long time ago in the back of my head as something that I've used. I'm like, this sounds awfully similar, so let's use it. So yeah, I guess back to Rahimi, I think it's just very confusing as to what the standard is now that lower courts are going to try to apply. And I think, some other people disagree with me on that. Chuck Michel would say that courts who think it's confusing are being disingenuous and they're just looking for, grasping for a way to deny people's rights. I'm a little more charitable than that. I think that
you both could be right.
I think that the state of the law is confusing for courts to implement because of this sort of confusion that the Supreme Court has caused, and some of that is coming from justices who outright in their concurrences said, if I could, I would overrule Bruin, but I can't. So I'm going to go along with the majority in this and take away Rahimi's rights. So that's what's causing some of the confusion, is because you wouldn't get buy-in from enough justices if you tried to go with a better, a stronger historical analog. There's a lot of horse trading that goes on behind the scenes of the Supreme Court.
I'm sure that's true, and I can't help but feel a little sympathy for the justices, because I've got to admit, it was hard for me to get behind Rahimi. Who of us really do want him to have guns to continue the crimes that he was committing? But
I don't want that man to have guns.
Yeah, none of us do. So I'm entirely with you on that. Oh, so if it gives the intermediate courts a reason to make denials, do you think that we're going to see something better come up to the Supreme Court, that we can try to get it clarified on? What's it going to take to get some clarity on where we can deny people's rights? Where are the ripples going to shake out on this?
So there are a number of cases working their way up across the country. I think there are a couple out of Chicago on their way up right now, related to magazine capacity and assault rifles and those kinds of things that are probably going to make it to the Supreme Court, and those things are going to give us some decisions that'll give us some clarity. I think those are closer to making it to certiorari, which is the Supreme Court agreeing to hear a case, than some of the California cases. There are a number of California cases that are in the Ninth Circuit right now on very similar issues: magazine capacity, the handgun roster, assault weapons bans. All of these things are sitting in the Ninth Circuit right now, in various stages of briefing and argument, and we're looking for Ninth Circuit decisions on those. And then whichever side loses is almost certain to file for a petition for writ of cert to the Supreme Court. But we may, before that happens, we may very well get decisions on some of these Midwestern cases that may make ours moot.
So really, we're just asking, how do we counteract that erosion? Will it take the magazine capacity cases? I mean, can we address the domestic violence restrictions again? How do we get back to where we wanted to be?
I think that these cases that are on their way up will provide a lot more clarity, because I think that they're going to have a very difficult time showing any kind of historical analog to a magazine capacity restriction, right? I think that's dead on arrival when it gets to the Supreme Court. And so I think we're going to have no problem getting a strong case out of them for that, which will reinforce the Second Amendment. It'll reinforce that historical analog standard, and it's going to be, I think, very good for us once it gets there. Right. I don't know what the Ninth Circuit's going to do with it. I don't really know what the Second Circuit is doing with them, but I think the Supreme Court is going to look at that as currently composed. Right. There's always a chance the Supreme Court changes before these things get there, and then who knows? Right. All bets are off. It's really tough to predict what's going to happen at that point. But as currently composed, if we can get these cases up there, I think we're going to get a strong Second Amendment ruling on a magazine capacity and an assault rifle ban and those kinds of things. That's really going to be helpful to clarify what that standard is in terms of the historical analogs. The domestic violence thing, I think, is really tough. We had a really interesting decision actually out of the Ninth Circuit a couple of months ago called Duarte, where the Ninth Circuit found, as applied to this guy, that a person who is a reformed felon, somebody who had a non-violent felony in his past and had been to prison, served his time and whatever, is not a prohibited person under federal law. So that's a really interesting decision out of the Ninth Circuit, saying not all felons are going to be prohibited forever.
That is interesting.
And it totally flows against all of our conventional wisdom of, if you're ever convicted of a felony, your Second Amendment rights are gone. And the Ninth Circuit said, no, not necessarily. He's a non-violent felon. If you embezzled some money from an employer 20 years ago and you've done your time and whatever, why should we take your guns away? It's a good question. It's a good question. And the Ninth Circuit seemed to say, yeah, well, maybe we shouldn't. So it's okay. So we're seeing some, cracks of light and those kinds of things, which, the Ninth Circuit historically is no friend of the Second Amendment. So it's interesting when something like that happens. So we'll see what they do with magazine capacities and those kinds of things. And ultimately, I hope we can get these things up there before the Supreme Court changes too much and get some really good guidance on these things. And then, the other aspect of that's interesting, of course, is how much deference does a new court pay to, establish precedent? Because what we're seeing right now is that the current court doesn't pay a lot of deference to established precedent, because they're overturning things like from the 1970s, like Roe versus Wade, and they just overturned the Chevron deference doctrine that's been in place for a very long time related to regulatory implementations. And, so they don't seem to have a lot of respect for established precedent, right? So then we get some changes in the court, and maybe they're not going to respect the established precedent. It's tough to know.
Yeah, that's going to get very unstable, and that's hard to know, but it almost brings up something you mentioned, Roe, that then you almost wonder about that difference between the Supreme Court having to step in and say, no, this is what the law is, this is what you should be doing, and the states. I mean, after all, Texas tried Rahimi, and they punished him several times. Why do we end up having to go out of our states? Why can't we just settle down and say our state's law? This is kind of a devil's advocate question. Our state's law is what we're bound by. Then you take the appeals that you've been having. The state law obviously isn't good enough.
With Rahimi in particular, it's totally baffling to me that man never had a felony conviction, considering his history of conduct. Right? Why wasn't he a prohibited person just according to state law? I don't know. But what he was charged with was a federal law that said that somebody who's subject to a domestic violence restraining order, if it meets certain criteria, is a prohibited person. And then he, of course, had a gun. And so the feds were charging him with that. It does seem that Texas absolutely had enough to prosecute and convict this man of something and get his Second Amendment rights gone. I don't know why that didn't happen. That's completely baffling to me. I feel like that was another part of the question.
Well, it kind of leads me into that question of why so many of us got interested in Rahimi. I mean, some of the gun rights organizations that I personally contribute to, they wrote briefs in support of it, and like I said, there's just this kind of an emotional tug of war for me because he was obviously so reprehensible. It goes to a title that you put on that article that you wrote: "Bad cases make bad law."
Yeah, I don't know why that kind of case goes up. It's completely baffling to me.
It really goes to our future. What do we want to fight? What do we want to get behind?
Right. Well, and it's a feature of our federalist system where we have we have a state penal code in California that outlaws a whole bunch of different conduct, and then of course there are federal laws, federal criminal laws that ban a lot of things, and that's where we got Duarte, was from a federal law saying any felon can't have a gun under 922A1 or something, or G1, 922G1, 18 USC 922G1 for those who are following along at home in your hymnals. And that was also similar to what was being challenged in Rahimi, was a federal law under 922, versus challenging a state law. And in some ways, federal laws have sort of a faster path to get up to the federal courts of appeal, right? Whereas a state law, if I wanted to challenge California's ban on a nonviolent felon having a gun, which California has a law that says no felon can have a gun. First I'd have to argue that at the trial court level, which I've made that argument and lost it several times since Bruin. Call them Bruin motions, like, hey, this guy should be allowed to have a gun, and the trial judges are like, yeah, no, we don't think so. But then I'd have to go to a state appeals court, and then the state Supreme Court, and then consider where it goes from there. Usually directly to the federal Supreme Court. There, you don't usually get federal appellate review of a state court decision. So then trying to get cert granted is very unlikely on that kind of a thing. So it's an interesting feature of our system that we have this duality of laws that, and a particular course of conduct can be prosecuted either at the state level or at the federal level. If I'm the defendant, in most cases, I'd rather be prosecuted at the state level. It's a less of a battle to get favorable sentencing and get to where I need to be.
Well, it kind of goes to what I almost saw as our summation. It is, what is the best method for us to for us to claw back the freedoms that we as law-abiding citizens have lost? You work in the courts every single day. Do we want to fight on the state level? Do we want to fight on the federal level? What's our best way to regain a little ground here?
I think the way to do it is to responsibly exercise our rights, right? A lot of it is a battle of public opinion. People who are gun people should, don't go around flaunting your guns and, brandishing them everywhere, of course. But, talk to your friends about it who are, more on the left and more anti-gun, and say, hey, you think I'm a responsible guy, right? Is there a reason that I shouldn't be allowed to carry a gun? And, start to work on that public opinion piece. And of course they'll say, well, no, you can call the police. And I say, well, how long does it take for the police to get there, right? If I'm getting mugged in an alley, are the police there to stop it? Well, no, I need to be able to responsibly handle that myself. God forbid I ever need to, but I'd like to have the ability to be prepared for that. And is there some reason that I shouldn't? I think that that's a conversation that people should be having frequently. And we have a tendency to shy away from it, right? I think we very frequently, I don't want to talk to my anti-gun friends, or well, a lot of us probably don't have anti-gun friends, right? I happen to have quite a few, and I have quite a few very liberal friends who are pro-gun. I'm a very middle of the road guy myself. Not beholden to either side politically. Obviously, I feel strongly about the Second Amendment, but I feel just as strongly about other things that the left supports. So it's really difficult. But I have a a varied group, social circle also, right? From
Yes,
my
yeah,
firearms
for that
instructor,
reason.
my firearms instructor friends who are very single issue voters on the Second Amendment, right? And then like my wife's family is all very liberal, and they know I have guns and they totally support that, and they're fine with it. So I think it starts with those conversations of and on social media, when people are blasting, we need more gun control and what. Well, what does that mean? What gun control would you actually like? What, and then getting more granular about it when there are major incidents that are terrible, right? Well, would any of the things you're proposing have stopped this from happening? I think the vast majority of the time the answer is no.
Correct.
The things that you would like to see as gun control would not have stopped this incident from happening. And it wouldn't stop most incidents from happening. So what is the rationale behind imposing these restrictions on us law-abiding gun owners when it's not going to stop the criminals? Where's the sense in that? And I think that those are reasonable conversations to have. And I think that what it comes down to is people don't understand each other's perspectives and hobbies, right? You may not want to fly an airplane, and you think it's silly that I do. But why would you want to ban that?
Restrict you from the airways. Yeah.
Yeah. Why would you want to ban me from doing that? Noise issues aside, and we actually have a big issue in Torrance right now with the Torrance airport and neighbors complaining about noise and all that. And they think it's just a rich person's game. And I'm like, well, I use my airplane as a tool in my business all the time. I flew to Port Santa Barbara on Monday. Like, these things happen.
Yeah.
So I think if you analogize it to other types of issues, I don't have any interest in knitting, but I don't think that you should be prohibited from it, right? There are a lot of things like that where people just don't understand that it's A, for sport, B, some people hunt for sustenance. Okay, great. And, the Supreme Court has now recognized that I have a right to personalized self-defense. And so, I should be allowed to do that. And by the way, when that crazy guy starts shooting in the mall, you're going to be real grateful that I'm there to take him down before he hurts you, right? The good guy with a gun is real. And, what's interesting is that narrative doesn't get out enough to the anti-gun crowd also, right? I read the Concealed Carry magazine and some of these other things that talk about these incidents when they happen. Actually, I have the magazine, sitting here on my desk. But people, I have people. Well, I never hear about that happening. I never hear about the good guy with a gun. Because you're not reading the types of materials where those things are published, and mainstream media doesn't put it out there much, right?
So maybe we need to mention it.
Yeah, we need to say, oh, yeah, did you hear about that incident in Texas where that guy in the church had his own gun and, took out the shooter? Yeah, that one did make national news last year. Yeah, so I think it really starts there. And then, it's a little by little on the legal front and finding the right cases to bring up and having people who are willing. It takes a lot of resources to do that, right? So, do you get backing from the California Rifle and Pistol Association or the NRA or other organizations to pay those legal fees and put in the resources? Or do we have people who are able to self-fund? My clients are paying me out of their pocket to go litigate these issues, and it's they're limited in how far they're willing to go. Like the one guy, I said, we should absolutely appeal this. I'd like to get a transcript and go with it. And he said, well, I'm out of money. I'm not willing to do that. I said, okay, well, you can apply again in 2 years because, I can't do it for free.
No. And then there the problem sits to catch the next guy or gal.
Well, and I think that the more we're going to have to get some appellate guidance on this new, appeal process for the California concealed carry licenses to give, the trial court judges some guidance. Other than right now, all we have is the statute, right? So, somebody's got to appeal these things, and hopefully we pick the right cases. I do a lot of DUI work also, and I'm in the California DUI Lawyers Association, and something that gets bantied about there a lot is, well, how do we pick the right cases to appeal? The California DMV is doing procedurally nonsense things, taking our clients' licenses away, and which case we're very careful about which cases we take up on appeal because we don't want to make bad law.
The same thing should apply to us when we're deciding which ones we want to submit briefs about and fund about. But of course, I don't think we had any choice on Rahimi. I think that the DOJ set that one up, and they knew that it was going to turn some things back. So we were not really in control of Rahimi. But you're absolutely right. We need to have some good cases to get behind. Well, what's the bottom line for network members from behind the enemy lines?
There is hope in California, right? We are making slow and steady progress. I am optimistic about the current state of things. I mean, we're in a better place now than we were 5 years ago, for sure, with respect to California's firearms laws and concealed carry licenses and those kinds of things. We're in a better place now than we were 2.5 years ago, and we're in a better place now than we were 10 months ago. So we're making progress, and there's light at the end of the tunnel. I think we are improving the situation in California, and I'm proud to be part of it.
That's wonderful. That's a great way to hear from you, and stay in touch with us. Let us know what we can do to push the ball forward too. But I'm proud of you, man. I think that's great. I really do.
Well, thank you very much. It's been a pleasure.